In the name of the Father, and the Son, and the Holy Spirit, amen. Lord Jesus, we ask you to be with us, to guide us, and give us wisdom. We ask you, Lord, for a deep sense of prudence during this time. We thank you for the gift of life, and we thank you for the gift of our parishioners. We ask, Lord, that they may leave a legacy that builds up your kingdom and you alone. We ask this through Christ our Lord. Amen. In the name of the Father, and the Son, and the Holy Spirit, amen. So I say this again, I think you're doing an incredible service to your family for doing this. The amount of people I've talked to in the past couple of weeks that don't have any of this prepared is really overwhelming. And I'm hoping even more come tomorrow night, because I think the Vikings are still playing, so that might have swayed some people. But I want to thank my team too. We had a team that's over a year that's been working together preparing these books. The Diocese of Bismarck has helped out a lot, and I just think, talking to our guys that are here, they said it's a really good book with a lot of really good information. So that's kind of your main resource, and then we're just going to kind of we have 5 different talking points. We're going to give these guys about 10 minutes. They can answer some questions. I'm going to try to moderate. So if we start going down a rabbit hole of personal, estate planning, I'm just going to step in and be like, we'll save that till the end. So don't be offended if I cut you off. We're just trying to get through this in about an hour and a half at the most. And then we can have the guys stick around if you want to come up and have actual question answer with them. So I think that's going to... and then the other thing I want you just to tell you, if you want to write this down, we're having a follow-up meeting to all of this, because we're going to give you a lot of information, then we're going to hope that you go home and make a bunch of decisions and then come back, and we can have your copies that we need at the parish and the funeral home and all these places on December 7th. So do you remember that, December 7th? And I'm just going to double check right here. I think it's at 7 p.m., but it's in my calendar, I know that. Sorry, it's right after the 10:30 Mass again. So it'll be this time on December 7th. So hopefully we can answer any more questions at the end of that. So we're going to start with the funeral. I've asked Nathan from Weigel Funeral Home just to we have a few talking points, and then he can answer some questions if needed.
Okay, thank you, Father Josh, and good morning, everyone. And those of you that care, the Vikings are down by 3 with 12 seconds left in Dublin. So there's a chance. I believe the Vikings have the ball.
Focus.
Yeah, so putting my phone away. Okay, folks, thanks again. And as Father Josh pointed out, I'm glad we are having this discussion. There are a lot of people when it comes to estate planning that are a little in the dark, so hopefully we can provide a little bit of insight and guidance for those of you that are here for this. I'm sure the kids are going to be bored to tears listening about estate planning, but again, thank you for sticking around for this. So, as Josh said, my name is Nathan Grubb. I'm a licensed funeral director and embalmer with Weigel and Buehler Larson Funeral Home here in Mandan. I've been a funeral director now for close to 30 years. So I will have a little Q&A period. Again, as Father pointed out, we don't want to get too far in the weeds with that. But what he asked me to touch on today, just basically 5 talking points. The benefits of pre-planning is where I'm going to focus. And there are a number of reasons to pre-plan, but what I'd like to do is just highlight the top 5. And pre-planning, what that means is that you're coming into the funeral home. We do have an advanced funeral planner, an individual that specializes in this. So generally don't meet with the funeral director, until it's an at-need situation. But we're always around the building, obviously, to answer any questions or concerns. And our advanced funeral planner is pretty well briefed on the ins and outs of funeral service. But number 1, the top reason to pre-plan is basically so your family knows your wishes. It takes the guesswork out of it. Sadly, many families experience disputes and hard feelings when there's a death in the family, especially if it's an unexpected death. Memories of loved ones' wishes sometimes contradict each other. Disagreements can arise. damaging the healing process. So, making your plans in advance, your loved ones, your kids, your siblings, they don't have to guess what you may have wanted. Secondly, urgent decisions are completed now in advance. This statistic blows my mind, but it's true. There's more than 150 decisions and tasks that must be completed within 24 to 48 hours after death. So knowing what type of service you want, knowing what type of disposition you want, whether you want to be cremated or whether you want a traditional funeral service, that is something you definitely want to discuss with your loved ones. I've been down that path where it takes families 3 to 4 days to decide upon what are we going to do with mom. What was mom's wishes? Did she want a traditional funeral service with burial, or did she talk to somebody about cremation? To get everybody on the same page, this is where pre-planning really is advantageous. So your family knows what your wishes were, and again, it takes a lot of the guesswork out of it. Thirdly, peace of mind. Arrangements are guaranteed to be carried out as you have directed. You and your family can feel comfortable. Number 4, funeral costs are addressed, and this is a big one. Funerals, much like weddings, are not cheap. A traditional funeral service, and Father asked me to kind of walk this through too. A traditional funeral service with burial, if you factor in all your cash advances, and what I mean by that is cemetery fees, certified copies of the death certificate, flowers, if you plan to do a lunch to follow the service, average funeral, traditional funeral is about $15,000. So it is significantly higher than what most people think. Cremation, little less expensive. I generally tell people it's about half the cost of a traditional funeral. You're eliminating some merchandise. You're not having to select a casket. You don't need a burial vault out at the cemetery. Now, in the Catholic Church, we point this out. Many of you know this already, but if you are to be cremated, all of your cremated remains are to be buried. There is no separation of cremated remains. There is no scattering of cremated remains. They must stay intact and must be buried in a timely manner. Okay? And the diocese comes down very hard on that. So, something to keep in mind. We get, as funeral directors, kind of get caught in the middle of that. Often, as Pastor Josh and Chris know. So, those are 4. Number 5 is your funds are safe. Medical assistant, asset protection is another one. And then also there's no probate or delay. And I know we have an attorney here with us that'll probably get more into those details. But most of the people that we see coming into pre-plan at the funeral home, they are in a Medicaid situation, which means that they are running out of money. They are going to a social worker. The social worker is saying, you need to get your funeral planned. Those families come in to meet with us. They set aside funds for their burial costs or for their disposition costs. That's not saying that that's what you have to wait for. That's just what we mostly see. No one's gets up at 7 in the morning and thinks, oh, I'm going to go pre-plan my funeral today. It's not something that people really want to think about, but there are some obviously major advantages to doing that in advance, and mostly so your family knows what your wishes are and you take a lot of stress load and financial burden off your family by doing so. So those are the 5 key points that I wanted to focus on. I know we're somewhat on a timeline, but I'm going to do just a quick Q&A. Is that okay? And then we'll move on. So anybody out there that would have an immediate question? And again, if you're bashful and don't want to bring it up here, contact either Weigel or Buehler Larson Funeral Home. We can answer hopefully most of your questions or concerns. But is there anything that anybody would have right away?
I got a question. Let's say the person who's supposed to be taking care of everything, we passed away and something happened to them. If we've got everything pre-planned and everything, you guys would go ahead and do it as, we give it to you. And you guys would do exactly. We would get, we're both, we want Christian church,
Mm-hmm.
funeral, and a lot of our family members say, no, you go get cremated, and,
And again, you could kind of get into some legal issues there, but yes, for the most part, yeah,
You would have, if we had everything prepaid, everything done.
pretty tough to override.
They talk to you and it's done.
Pretty tough to override. Yeah, not saying it's impossible, but pretty.
It can happen.
Oh, yeah.
My brother passed away in 2 weeks and he was 54 years old, just like that. So I mean, the person who's taking care of our stuff actually maybe, it can happen. I've been kind of thinking about it all last night, about what would happen then, if we would have it on. As long as we have Christian burial, I don't care about anything else. The money can go wherever. Thank you.
Yeah, you're welcome.
What was the question and what's the answer?
Her question is if she has like a pre-planned funeral and she comes in and meets with us at the funeral home and says, I want a traditional ceremony at the Catholic Church, I want to be buried at this cemetery. Can any children or family members change that? Essentially, that's what you're asking, yeah. Again, you can kind of get into the legal weeds here, and an attorney, I've really never seen it in my 30 years, how that can be, changed. Not to say it can't, but usually if we have something in writing, in file, what I would suggest, and again, I'm not an attorney, but if you're concerned about that, probably put something in your will, indicating that that's what you want. Okay. All right. Well, thank you for the opportunity. Again, if any of you have any questions, concerns, please contact us at either Weigel or Bueller Larson. Thank you.
I just want to put one more little exclamation point on that. Like when you say like a lot of parents will be like, well, my kids will just figure it out. No, they won't. I mean, the amount, I would say, percentage-wise, I'd say about 75% don't figure it out. 25 maybe, and those are like super faithful kids that all get along. They might figure it out, and otherwise there's gonna be arguments over the readings. And quite honestly, like when my mom passed, we had all of her stuff. So like, I'm grieving. I don't want to be thinking about what mom would want for a reading. I just want it, right? Even, this one's probably going a bit too far, but even like an obituary, like that is so hard to write when it's immediately after the person passed, so just to think about all that stuff. And again, everything you can pre-plan, you're going to save your family that planning, which is very difficult when they're grieving. So just a little exclamation point on that. Second, I want to bring up as far as all the money man, right? Kyle Engelhardt works for Edward Jones, asked him to come and speak on a few talking points in regards to estate planning. Kyle.
Father, thanks for lining this up. Thanks for having us. Again, I'm Kyle Engelhardt. I have an Edward Jones office, 301 East Front Avenue in Bismarck. And we were asked to talk about a couple of things. One, what should I be doing to plan in advance? Two, what should I be doing at the passing of a spouse, right? And then thirdly, what should I be doing after the loss of both parents? So if I'm a child, right, or I'm an executor for an estate. And so I'll just start by saying you want to start as you intend to finish. So it is so important to begin to have a conversation about what that plan looks like for you. And if you're married with your spouse, I would say even before marriage and early in the marriage. And it's a conversation that should be continually ongoing as to what you want things to look like as kids come into the picture, as kids age out of the home. There are different financial and legal and tax considerations for all of those circumstances. And so what I'm going to say is going to be very general advice, but everyone's circumstances are different. And so depending upon what stage of life you're at, what your tax status is, your marital status is, things are going to change. And so the thing I would highlight is, we talk about, in my industry, about a three-legged stool. And so the three-legged stool of your financial wellness is, your finances, right? So these are gonna be your assets, the things that you've accumulated over your life of work, leading towards retirement and taking care of you in retirement. There's also going to be the legal aspect. Okay? And so you need to have good counsel with regards to the legal situations that impact you, and then also good tax advice, right? And so, I provide financial counsel for a living, but I also encourage all of my clients to seek out good tax advice, good legal advice, and make sure that you are communicating those plans between those individuals. Now, I can't tell you the number of times where someone has come in and said, "Oh, Kyle, I have an estate plan, or I've got a will, or I've got a trust," and the reality, but I don't know about it. And so titling is extremely important in terms of your estate plan. If your estate plan isn't funded, you paid for a really nice piece of paper, right? But the trust language or the will language can be preempted because of things that you've done prior to your passing. So if you've named beneficiaries on an IRA, or you've added a transfer on death to a brokerage account or a bank account, right? Those are gonna preempt any sort of probate process. So if you've created a trust document, or if you've set up a will, but you've named beneficiaries on an account, those assets are gonna follow those named beneficiaries on an account. And so that's why it's so important that, hey, gosh, you're going through the onboarding process with your company and they tell you you should name beneficiaries to your 401k, right? And you've named those things, and then later in life, you come up with a will or a trust plan, but you haven't changed the titling on those documents, right? They're gonna come into conflict with one another. And so that's something that you wanna plan for at the outset. And that's one thing that I do a lot with my clients. And so while you're both still living, to know what those plans are, and to pick a point person. You can be your own point person, but a lot of times my clients might have a tax preparer who is their, what I would call, most trusted contact, who's helping them come up with the plan, and then they're coordinating with the legal and the finance to make sure that that's in place. I have a number of clients who, I'm the point person, right, in the estate plan, but I'm not a CPA, right, and I'm not an attorney, and so we have to find those parties and bring those individuals together to make sure that we're coming up with a plan. But at the outset, it is just so important that if you're not comfortable having that conversation yourself, you don't know where to begin to have that conversation within your marriage. Finances is a difficult conversation, for some couples. It's important that you seek out someone who can kind of help walk you through the different implications, based off of your circumstances. But so I would just say, at the outset, as you're going through the planning, it is so important. Titling is extremely important on assets that you have. So if you have a home, thinking about things like a transfer on death deed on your house to make sure you know who the assets are gonna go to next. If you've got IRAs or 401ks, that you've got named beneficiaries, if you've got brokerage accounts or bank accounts, that you've got payables on death or TODs on those accounts, so that we know who the assets are gonna go to. Because even if you're married and you have individual accounts, right, there's no certainty that even your spouse is going to be able to be the person who controls things after you pass. And so I'm sure it will get talked about, but in my practice, we focus a ton on making sure individuals have either a springing or a durable power of attorney in place, so that we know who gets to control the finances for individuals if you become incapacitated, or if you pass away, then it falls to your executor or your spouse. So Upon the passing of a spouse or a loved one, generally speaking, it's working with the funeral home to make sure that you're getting a copy of a death certificate, a certified copy of a death certificate. Make sure you're getting enough of those to be able to provide to the various financial institutions that you have your accounts at, because that's really what starts the estate processing for the account. They can't really move forward without that. If you have accounts titled, you have beneficiaries and or transfers on death in place, you get to actually preempt the entire probate process. So it makes things move, a lot faster for a spouse or a loved one. If somebody has that correct titling in place on an account, get a copy of the death certificate. In my office, we can transfer the assets, have them renamed in like 10 business days, which is a lot faster. It's a lot smoother process than going through a probate. Other things that you'll want to work with if you're on Social Security or receiving Social Security benefits, you'll want to notify or contact the local Social Security administrator to make sure that, especially in the event of, say, one spouse has a higher Social Security benefit than the other spouse, you want to make sure that you're getting those benefits adjusted, because there are spousal considerations. And that would be true of any other protected or insured income sources that you have in retirement. So think of a pension, right? Think of some sort of annuity that has a spousal continuation. And making sure that you have a master file someplace of where all those assets are. We try to emphasize for clients, it's so important to make sure you're over time consolidating those assets for yourself. As I like to say, people worry about diversification and they don't want to have all their eggs in one basket, but you do want all your chickens on the same farm, okay? So it's super important that you've got kind of that consolidated plan, because after both parents' spouse, I'll tell you, kids don't know where anything is. They don't know where anything is, and they will spend not just hours, but days or weeks going through paperwork that they find at home, finding, that like auto owner's insurance policy that you took out that one time because you got a discount, and now there's like a $2,000 annuity that's held out someplace. And all of those have to go through an estate process. So making sure that, in a fire safe or with your financial advisor, that you've shared a comprehensive list of the assets that you have, so that it's easy to walk through. And then I would emphasize, we do this within my own family. This is something we started doing, with my parents over the last several years, but making sure that whether it is your beneficiaries or your executor, that you're having a conversation with them about what the plan is, what that looks like. It's so important that you're letting people in. People can be so guarded about their finances because they worked really, really hard over a lifetime, to gather the assets. They don't necessarily want to share with, their siblings or their children about how much money they have, because those can be awkward conversations. But you don't have to put things in dollars and cents. It's really just a matter of, hey, if there's money left over, this is how I would like it to be handled. These are who they're going to. You can name not only individuals, right, but also individual institutions as a bequest. And so it's just, very, very important that you work through that process. It's similar when a spouse dies to when both parents die. Again, it's just a matter of making sure you're getting a certified copy of the death certificate, and you're providing that to your financial advisor or wherever your other financial assets are. But those things can't wait until you've passed away. If you don't have these things in place, if you aren't having these conversations now, it's going to be a mess. It's just going to be a total mess for your kids or your spouse. And so I would end with that, to make sure that you start as you intend to finish, that you come up with a plan, that you're thinking about that three-legged stool, whether it's your finances, your tax, and the legal framework that you want to use. And then you seek out good counsel to help you begin having those conversations, because they're certainly not natural conversations, and it takes some time. So if there's any questions, take a question. Yes?
If you have a trust and you've got your kids in your trust, that pretty much alleviates a lot of this, what you just mentioned. You don't really have, if you've got everything that you own in your trust, you're pretty much taken care of, right?
So the question is, if you have a trust and you have named beneficiaries, your kids are your named beneficiaries in your trust, are you taken care of? And my question to you would be, do you have your assets titled in the name of the trust, or do you have the trust named as the beneficiary on your financial accounts? Because if you don't have that in place, right? Again, I'll let the lawyer speak to that, but that document won't govern. So if you've already named, for instance, hey, I've got a 401k and I was married, and back in 1982, I named my first spouse as the beneficiary of my 401k, right? And that's the named beneficiary, and I forgot about it. I got divorced, I got remarried, I pass away, that spouse, that former spouse still survives me, and you named them as the beneficiary. You have the trust, but this is a named beneficiary. This is going to preempt that document. So those assets are going to go to the named beneficiary on that account, right? As opposed to who you wanted it to go to. It won't pass through the trust because that other naming right is going to be. So that, again, that's why I mean the funding. It's called funding the trust, right? That process of funding is vitally important, and to make sure that you've worked with whatever various financial institutions that you have to change the titling to make sure that trust is governed.
We're pretty much cut and dry, it's just 4 people and everything in it.
Yeah, and that's great, but what you want to do is then make sure that, if I've got the Kyle O. Engelhart Revocable Living Trust, the Kyle O. Engelhart Revocable Living Trust is the named beneficiary on my brokerage account, right? So when I pass, it passes to the trust, which is an entity. But if I'm married, but I have, Father Walt's named as the beneficiary of my IRA, right? He'd like that. It's gonna go to him, right? So that funding aspect is extremely important.
Yes.
Other questions?
So if I have a joint account, my name and my wife's name together, and our 2 children are the beneficiaries, is everything taken care of?
Yeah, so in terms of those assets, right, you've got a joint with rights of survivorship account, let's call it. If something happens to you, it's gonna pass to her. If something happens to her, it's gonna pass to you. And then you have those named beneficiaries, and then ultimately they pass away. Yeah, exactly. You bring in a copy of the death certificate. It's non-probatable, right, because those named beneficiaries are in place. And those assets they'll have to set up accounts, right? They'll have to provide, some information, but then the assets would pass directly to them. The only stipulation is, though, right, on that is, in a joint account, when you pass, it's going to become a single account. That surviving spouse would still have the right to change the beneficiaries after you pass. And so, that's always a consideration that people have to think about, when they are going through estate planning.
If you, say you have 2 beneficiaries on there, will they each, say you have 2, would each one get 50%?
That's entirely up to you, right? They don't have to be equal beneficiaries. If you like one kid more, and you want to give 60% to one and 40% to another, you can do that. Yeah? You have to say that, you have to specify. It will default to equal. So if you want it to be a different percentage, or again, like that's a great way to do a bequest, right? So if I wanna give, I give 40% to this kid and 40% to this kid and 10% to the church and 10% to some other charity, right? You can name it that way. Or 20%. I'll leave it there, guys, thanks, yeah.
Thanks, Pat. Next we have maybe the most important, the attorney. Pat Brook, I invited up to speak on a couple talking points for the legal aspect.
I like that attorneys being the most important. I'm Patrick Brook. I'm an attorney. Used to be in private practice. I work in house counsel for an organization called Aircraft Owners and Pilots Association. So I have no stake in this. I'm not looking for wills or anything like that. I'm strictly here to tell you about the process, what I know. I've done several in private practice. So I have some working knowledge of it, practical knowledge. But I want to hit on two of the things that Kyle said. He's exactly right. I'm going to skip around here a little bit. But that is the most important thing with wills versus having a will and the purpose of a will, and then estate planning in general. So there's what's called probate assets and non-probate assets. And what he is talking about, probably primarily what you deal with, is non-probate assets. So that's an easy way to think of it is anytime there's a named beneficiary, or it's not titled as sole ownership. So you're looking at payable on death, transfer on death, things like that. When that happens, it is outside of the will, okay? So the biggest conflict we see usually is where someone did a will years ago, simple will, then they went into someone like Kyle and they didn't tell Kyle about the will, did everything as named beneficiaries, and then you have a conflict. So that's, if you ever go in to meet with Kyle, he's probably gonna tell you, you know, when you're estate planning, go talk to an attorney, talk to an accountant. I don't know who else you would talk to. Those are the only two I can think of. Funeral, yep. Just heard from that. So that's what you wanna do, is you wanna do a complete estate plan. If you're revisiting it, your attorney's not here anymore, your financial planner is a new one, tell them both everything, so you don't get in that situation. Okay, so we'll start at the beginning. The areas I'm supposed to cover. Do I really need a will? Short answer, yes, but we'll go over that. What if I have minor children but don't have a will? What happens to them if I pass while they're minor children? If I don't have a will my children fight? Probably. And how long does it take and what is the average cost of getting a will? So I'll go over some of that stuff. I think the most important thing here is to talk about what a will is, and I kind of jumped around and went into the probate, non-probate assets, but a will, just a legal document, piece of paper. The requirements for a will are that it must be in writing, must be signed by the testator, that's the person making the will. Some attorneys still use testatrix for females, some don't. Has to have two witnesses in North Dakota, and every state's kind of different. I think most follow the Uniform Probate Code. And it must be notarized or self-notarizing, and the person writing the will must have the capacity to make the will, okay? That's kind of the general guidelines for any will. They only cover certain property, certain types of property. So this is what we were talking about, probate and non-probate assets. Think of vehicles, cars, you know, toys, ATVs, things like that. Real estate that's like titled only in your name, sole name, no right of survivorship, transfer on death, things like that. Investment brokerage accounts without a beneficiary listed. Did you get that much?
I try not to.
Yeah, happens sometimes. It's probably more the client forgetting, right, to give you the information. Yeah. Personal property, furniture, jewelry, toys, livestock, firearms, arts, collectibles, heirlooms, things like that. That's all covered by a will. Sometimes business interests like solely owned LLCs, but usually in the LLC articles, you'll have something that discusses what happens if you pass. So what that means is they don't go through the will, okay? That would be separate from the will. And when we say that, what I mean is that when you pass, there's still gonna be a probate process. There's a myth out there that just because you have a will, you don't have to go through probate. You still do, it just guides the probate process and you control what happens versus not having a will and going through probate is messy, or can be messy, okay? So basically you're giving yourself, by writing a will, the power to, or the control over how to dispose, gift your specific assets listed in the will, okay? It avoids what's called the default intestacy rule. So dying without a will is called dying intestate, means you didn't have a will. If you do that, every state has rules on what happens to your possessions, okay? So, long story short, you want to trust yourself, your friends, your family, the people you list. You don't want to trust the state, right? I mean, you can if you want, but then you have no control, and that's where the issues come in usually. Okay, so quick example of intestate succession in North Dakota, and I did look this up before this talk. So if you die unmarried without a will, property would go to your children. If you don't have any children, it goes to your parents. If you don't have any parents living, and these are living, goes to your siblings. If you don't have siblings, then there's extended relatives, and then it goes to the state of North Dakota, okay? So you want to control it, and the will is usually the best way to do that, or estate planning in general, okay? Skip ahead here. So this is an important one for younger parents, or parents of minor children, I should say. If you die without a will, or if you die with a will and your will doesn't address who will look after your children, and you and your spouse both pass away at the same time, the court is gonna pick a guardian for your children. You're gonna be kind of out of the picture. Now, they may pick a good guardian, you don't know, you just don't have control over that. So a will allows you to do that. It allows you to put alternates in there. It allows you to set up how you would want the money that you leave behind controlled. You can put it in a trust. You can say they get X amount at age 20, 25, a third at 18, a third at 21, a third at 25. If you don't do that, it's all gonna go to them at 18, okay? And again, you won't have control over it. So with a will, you get to name a guardian, alternate guardians. You get to direct how the children inherit the property, and you get to set out trusts and timelines, so more control again. The next question, if there is no will, do children really fight? Kind of a double-edged sword, because like Kyle was saying, if you like one kid more and you give them less or give them more, that creates issues too. Generally though, generally speaking, if you die without a will or any estate planning, it's chaos. If you don't have a advanced healthcare directive, like we're gonna talk about here in a second, if you don't have your financial planning done, if you don't have your funeral planning done, it just puts a big burden on the family, and it's not a good time to do that. Emotions are high, so get a will. One of my first cases in probate was actually dealing with that. Mom died, 8 kids, no will. Dad had passed away years ago. Got into a huge fight over it, and the son pulled out her diary and said she did write a will, a holographic will. So that's, you can actually, there's a rule for writing out wills. You have to prove certain things, but created a huge dispute, and there was a lot of money. It was a big farm. So to avoid all that, she could have just wrote a will. Okay. So how do you get this process rolling? There's, I saw the handouts for the free will writing whole internet thing like LegalZoom. I don't know what the one is called. that you have the sheet on. Good idea, for something simple. I advocate for attorneys. I think it's a good idea. When I bought my first house, I tried to fix the toilet. Thought it was simple, watched a lot of YouTube videos, did it for free. It didn't work. Had to hire a plumber, it was expensive, but worth it, right? Kind of like lawyers. If you do it yourself, you might screw something up. And then it's costly on the back end, and you don't want that. What do lawyers charge? It depends. If it's a simple will, when I was in private practice, it was $250 for a will. But every lawyer is different. Usually, if I did estate planning, it was, I would do a power of attorney, healthcare directive, and a will. And if it was like a husband and wife, that would be 6 documents, so I would do, I don't know, $700, something like that. I think that was on the low end. But I like doing them. I always thought I couldn't make a living just writing wills, but yeah, so I've seen, depending on the complexity of the estate, if there's trust, I've seen $20,000 as a number, but it all depends on your personal situation and what you have going on. In Bismarck, Mandan, we have a lot of attorneys. There's a lot of competition out there. I would talk to several. I'd get opinions, see who you like, see what their process is, and do it that way. I truly think that's the best way to do it, working with a CPA, a financial advisor, the funeral home, and an attorney, and getting it done right. Now, I understand not everyone can do that and may not be able to afford it. But consider this, if you have to go through a missy probate attorneys are expensive, very expensive. So it's kind of either you pay some more now or you have to pay later. Okay, the time frame. I would say probably, I don't know, a simple will I could do in like a day if I wasn't busy. But I would say around a month is what it takes attorneys. Typically what they're gonna do is they're gonna give you a questionnaire, interview type form to fill out, kind of like what's in the book. Discuss what you want, what your needs are, who you want as guardians for children if you have that. If you have grandchildren, do you want a trust set up for them? What your financial background is like, what your assets are, what financial planner you're working with. And then typically you'll get that information back, they'll draft something up, you'll review the drafts, might go through several drafts, and then ultimately a signing. And then from time to time, you're gonna wanna update that. So if you wrote one when you had minor children, now they're all in college, and your old will kind of doesn't make sense anymore, you can update that at any time. It's pretty simple to do. So with that, I don't know, I think that was 10 minutes. I'll take questions, but with the caveat that I understand law goes down a rabbit hole pretty quick. If you have a more complex question, maybe come and see me after the talk, I think. But general questions I'll take. I didn't mean to scare anyone with that, but it does. Like, I used to teach at UMary, and every time I talked about any subject like torts or property contracts, you just have to cut students off and say, we can't go down a rabbit hole. Yes?
Just for the good of can you just talk a little bit about the difference between a springing power of attorney
And a durable.
power of attorney?
Yeah, so 2 types of, are you gonna talk about that in yours, or your healthcare directives? Okay, so springing and durable. Durable power of attorney general durable power of attorney is a way for you to draft up a document to control your financial affairs, to say that the agent that you pick can write checks, access your bank account, whatever's in the power of attorney, but it's usually financial stuff, buy and sell stock. They're basically an agent for you. And what it does is it allows you to make that effective the moment it's signed, and then you can take it away by terminating it with a written document, okay? I generally went with durable power of attorneys because they're easier. The springing power of attorney says the person has to be incapacitated. That creates a problem, usually because you're scrambling, if something happens. The benefit of that is I guess, a trust issue where if you designate an agent and a durable power of attorney and you don't like them, but you don't have time to revoke the power of attorney, I don't know, I think most attorneys will do general durable power of attorneys, but yeah, one takes effect only on a triggering event of you become incapacitated. The other takes effect immediately when you sign or give them permission. And the purpose of it is usually strictly financial decisions.
And it's good until,
So you could do a duration on one. I can't remember, I don't know what that's called, maybe in the springing power of attorney. But general durable power of attorney, it will be outlined until terminated, until you revoke it. And
Or death.
death, yep, correct. Yes,
Probate, what exactly is probate?
probate is just the court process, yeah, it's when you pass away, the court is gonna take, the death certificate, the letters, testamentary, the will, all these documents gathered, they're gonna appoint a personal representative of your estate, which you can designate, or you would designate in your will. If you don't designate it in your will, the court's gonna do it for you, okay? So this probate process is the court looking at everything, paying off, making sure that your creditors are paid off, your expenses are paid, whether or not you have a will, they're gonna see what your intentions are for dividing up the money, or your estate, your assets. So a will goes through probate, but it's guided. It's dictated by, or if you die with a will, your intentions are dictated by the will, okay? If you pass intestate without a will, you're gonna go through probate, and the judge is gonna go through and the court is gonna make these decisions.
So as long as you have joint ownership, you have joint everything on your accounts, is there any reason for this probate? Do they automatically come in and just say,
They still will,
you can't have nothing until I look at it?
no, they still would, so let's say, I guess hypothetically, your scenario is you pass no will, but you think you have everything as a non-probate asset, right? The court's still gonna go through and verify this stuff because you could have made an error. It could be a probate asset when you thought it was a non-probate asset. But yeah, I mean, theoretically, that could work. And that's one of the scenarios, I would guess, you could get around a will, but you're still not gonna be able to designate a personal representative if there was an issue, and if you had children or I'm trying to think what else. Children or anything like that, then the will, not having a will would hurt you there. But if you were 100% certain that you had everything non-probate, you could do that, but you could also do that with a will and just say, here's my intentions. I believe everything's a non-probate asset, but if not, there's ways of doing that, so, yeah. Was that the question?
Yeah, I guess so. So in other words, when one of us die, we send a death certificate to a probate department or to who?
Yeah, there's a court process for that. So North Dakota actually has a really good self-help website. They have a whole formal and informal probate process, and they'll walk you through that. I would start there because it's not simple necessarily. But yeah, I would take a look at that. It outlines it very well, like in detail, on what you need to get to court. And clerks are usually pretty helpful with that stuff.
Do you know where that website is?
Yeah, it's on the North Dakota Supreme Court webpage, indycourts.gov, and then you'll see a self-help. I think it's on the right side. I can't remember. It's pretty, or if you Google self-help probate North Dakota, it will come up.
Who initiates this probate? Does the family do it, or does the state do it automatically?
Usually the family would do it, yeah.
Because you can't get anything until you do it.
Right, yep. Well, yeah. People do, but yeah. Legally,
The house is
correct.
The house was
Okay.
Moving right along. North Dakota Catholic Conference Representative David Tamassia asked him to talk about the medical directives, which I think is extremely important. I mean, all these things are extremely important, but this is a really big one, and who you appoint to help with medical directives is big. Durable power of attorney is huge. Making sure you have somebody for that can make a lot of decisions and things a little bit easier on the family along, especially with this, because this isn't the actual dying process, right? So, David.
Not necessarily, but I'll say that. Good afternoon, everybody. So again, my name is David Tamassia. I'm the Executive Director of the North Dakota Catholic Conference. Just out of curiosity, who knows what the North Dakota Catholic Conference is and what we do, just by show of hands? Okay, not many. Yeah, I usually find that to be the case. So just to inform you and educate you a little bit, the North Dakota Catholic Conference is the voice on public policy for the Catholic Church in North Dakota. And so what that means is I work for the two Catholic bishops in North Dakota, Bishop Kagan of the Bismarck Diocese and Bishop Fulda of the Fargo Diocese, to make sure that the Catholic Church's voice is heard and advocated for in the political arena, especially at the state level. So I spend a lot of time before the state legislature and with state legislators, advocating for positions on abortion, care for the homeless, treatment of people with disabilities, anything that you can imagine that the Catholic Church cares about. I try to be involved in that and make sure that we have laws that are protecting and standing up for those people. But one of the things that we also do as a charitable measure is we provide Catholic healthcare directives to make sure that healthcare directives are provided to people in North Dakota that fit and are in line with Catholic teaching, okay? And so you might ask yourself, what is a healthcare directive? So a healthcare directive is a legal document that provides written instructions on the kind of medical care and treatment that you would like if you become incapacitated, or it's the appointment of a healthcare agent to carry out your wishes about the type of medical care and treatment you'd like if you're incapacitated, or both. Okay, so let me say that again. A healthcare directive is a legal document that provides written instructions on the kind of medical care and treatment that you would want to have if you become incapacitated, or it designates a healthcare agent, a live person, to make those decisions for you and advocate for you, or both. So that term, healthcare directive, is what we use in the state of North Dakota. Sometimes people will use the term advance directive. That means the same thing. People will use the term, you may have heard the term living will. So that's basically instructions while you're still alive about the care that you want to be given to you when you're incapacitated. It's your will while alive, living will. Durable power of attorney for healthcare decisions, or proxy, healthcare proxy. That's referring to a person that makes these decisions for you. So those words are synonymous, but in the state of North Dakota, we use the term healthcare directive and then healthcare agent to refer to the person. Now, who needs a healthcare directive? And the answer to that is everybody that's over the age of 18. It's not just an end-of-life situation. It can be, but it's not just that. Because to be incapacitated can happen to anybody you could be 25 years of age and be in a terrible car accident and be put in a coma. You're incapacitated. You can't tell the healthcare providers the kind of care that you want because you are in a coma or unconscious or what have you. So a healthcare directive is really for anybody at any age over the age of 18. And so I guess the two questions that were given to me on the outline is it important to have one? And what would happen if I didn't? And the answer is yes, it's very important that you have one. And the reason for that is because if you don't have a healthcare directive that gives written instructions about the kind of care and treatment that you want, and you haven't appointed somebody to act on your behalf, advocate for you, you're gonna leave it up to others who, it might be a family member, but it might be a family member who maybe their values don't necessarily line up with yours. And there's a statutory order that the state follows. First, if you have a guardian, if not that, then a spouse. If that not that, your adult children, and it doesn't specify which one, they could disagree. Then it goes to your adult parents. So there's a kind of lineup of people that would make those decisions for you, but you don't get to decide who that is. That's decided then by the state if you don't have a healthcare directive. The other thing that can happen is even if you do have somebody, it's your spouse, and you totally trust your spouse, it can be very overwhelming in a situation when you're incapacitated to know what to do. And the nice thing about a healthcare directive that both gives written instructions and appoints a particular person as your healthcare agent is it provides that kind of comfort to know that your wishes are going to be followed. And even if it's not necessarily spelled out precisely, because a healthcare directive has to be fairly general, but it has to be general enough to cover a wide variety of situations, but specific enough to provide guidance to the healthcare team and your healthcare agent. But if you don't have that, then you risk having people making decisions for you that would go against your values and your principles. And so I don't know if you got this or not, but in the back of the room, the North Dakota Catholic Conference provides free of charge Catholic healthcare directives. And so if you look in the back, if you didn't get it, I have extra ones. But this blue paper, and then inside there's a white sheet. This is a Catholic healthcare directive. And so to be clear, this is something that's a Catholic healthcare directive. It's consistent with Catholic moral teaching and bioethics, especially concerning end-of-life type issues, and the kind of care that you're required to do, and the kind that could be optional. But anyway, it's in line with Catholic teaching, and it's been vetted by both bishops, right? It's been approved by the bishops, thoroughly vetted. It's in line with Catholic teaching. And so maybe if I could just briefly kind of go through this with you. So the blue paper is a guide. So it answers frequently asked questions, and it's a guide on healthcare directives in general. The white paper on the inside is an actual Catholic healthcare directive that you could sit down with your family and fill out. And so I'm going to in just a couple minutes time, just briefly go through the white paper, the actual Catholic healthcare directive. So if you look at the very top of the page, it says My Healthcare Agent. It gives a space for you to write your name, and then you appoint a healthcare agent, so a person who would make these decisions for you on your behalf if you're incapacitated, and then a space for an alternate agent. And then if you look on the second page at the top, there's a space to fill in the contact information for your healthcare agent and the alternate. So that's the first thing that you would do in filling out one of these Catholic healthcare directives. The second part you look is My Wishes. I'm not going to go through all that, I don't have enough time, but that's the part where it really starts to lay out principles, Catholic principles about medical care and treatment for somebody who's incapacitated. Maybe the one that I just want to underscore is the notion that under Catholic moral teaching, we're always required to use ordinary medical care and treatment to preserve our life, right? So ordinary care and treatment refers to anything that has a reasonable hope of benefit and it's not overly burdensome, the treatment. So, for example, somebody who's a diabetic, insulin Insulin is considered ordinary care and treatment. It offers a reasonable hope of benefit. You might die if you don't use it. And it's not, it might be annoying, but it's not overly burdensome, right? And when I say overly burdensome, it refers to things like causes extreme pain or might bankrupt the family, things like that. The thing that you're not necessarily required to do is what's called extraordinary medical care and treatment. And that means that either the treatment doesn't provide a reasonable hope of benefit, or it's so excessively burdensome that you're not required to do it. And you could do it, but you're not morally required to. And there's some nuances that have to be made. That's very different than you've heard euthanasia, where someone's putting someone to death. That's clearly a grave moral evil that can never be accepted, but not necessarily choosing to do extraordinary care and treatment when someone, it's just allowing the dying process to take place. That's morally acceptable in the Catholic Church's eyes. So an example of that would be, let's say you had a very elderly person whose heart has heart failure and they're dying of heart failure. You wouldn't necessarily have to choose to get a heart transplant for that person. That could be extraordinarily burdensome because the pain, and it might kill them, the surgery itself. It might not offer reasonable hope of benefit to someone at that stage in life. So that's just an example. It might bankrupt the family, and there could be lots of reasons why that would not necessarily be something you'd be morally required to do. If you look at the very bottom of that, there's a space to add some additional directives. That's where you can put in things that you would like done. If you were in a hospital bed and you couldn't speak or communicate, what would you want? So for me, I want family members around me praying the rosary. That'd be my number one thing. My number two thing I put down there is please contact my parish priest and make sure my spiritual needs are being taken care of. That'd be the second thing. And the third thing is, and I do recommend this, is I would say, if there are any moral questions, please contact the diocesan bioethicist or the National Catholic Bioethics Center. And I'll repeat that. If there are any moral questions where guidance is needed, please contact the diocesan bioethicist. It's Father Robert Shea here. But I wouldn't put the name because you don't know down the line, it might be somebody else. But this is a priest in the diocese that's been trained in bioethics, that if there were questions and you weren't clear, if there had to be some guidance, you could get easy guidance, not easy guidance, but you could get clear guidance from someone who really knows what they're talking about from a Catholic perspective. And then I also just recommend the National Catholic Bioethics Center. They guide the bishops. It's an organization that's located in Philadelphia, and they're just fantastic. So University of Mary has a joint master's program in bioethics that they pair with the National Catholic Bioethics Center to do. Very trustworthy organization. Okay, so if you turn to the next page, right beneath where you designate and give the contact information for your healthcare agents, there's an option to become an organ donor. You don't have to do that, but if you wanted to, you could designate that section. Turn to the very next page. So this would be the third page. This is where you make the document legal. So once you've filled out the other parts, it has to be authenticated. And so you see at the top of the page, there's a place for you to sign and date and indicate where it was signed and authenticated. But it has to be done before a witness. And so doing that, the first option is you can do it before a notary public. So you could go to your local bank. I think every bank has a notary, and do it there, and that's very easy. The second option would be before two witnesses. So, but it can't be, if you look on the prior page, there's a whole list of people it can't be. It can't be blood relatives or spouses or anybody that might have an interest in your estate. And it could be someone at the hospital. That could be one person, but it could only be one of them, and then it'd have to be somebody else that's not related to you. So that would be what would make the healthcare directive legal by authenticating it. And then the last thing you would do is you would just make sure to keep a copy of your healthcare directive in a safe place at home, and then disseminate it. Disseminate it to the person that you've chosen to be your healthcare agent. Disseminate it to family members. Disseminate it, send it to your doctor or to your hospital if you're a regular patient, to your hospital, to make sure that they have copies of this document. And then last thing, I didn't say it when I started, but as far as the healthcare agent themselves, the person you want is somebody who first of all cares about you, and then secondly, that their values align with yours. And that's why I said sometimes you don't want to just leave it to chance to family members, because sometimes our family members, we love them and they love us, but their values, they may fall away from the Catholic Church, and they just may not necessarily align with us. So when you're choosing that person, make sure that their values meet your values, and then talk to them ahead of time. Don't just designate somebody, make sure that they know and they've agreed that they can fulfill that role. So I'll end right there, and if there are any questions. I have cards, I can leave you, I'm an attorney also, and I have a doctorate in theology, and I've done a lot of work in moral theology and bioethics. So any questions that you might have, just let me know and I'll give you my card and we can talk later.
You have a question?
This might be a weird question, but with Catholics with organ donation, I know you said before that the cremation has to be in the same place.
Did you say about cremation?
No,
With organ donation.
Okay, okay, go ahead, sorry.
Is organ donation with Catholics, it's morally acceptable, correct?
Correct. As long as you're dead. Yeah, and he's totally serious. So, from the Catholic Church's perspective, it can be an act of charity to give an organ after you've died to another person who could benefit from that. It could save their life. That is an act of charity. It can be an act of charity while you're still living. You know, people that donate one of their kidneys because they can function with just one, not two. But, and this is a big issue today, is from the Catholic Church's perspective, the person has to be dead. You can't, the organ donation can't be the thing that caused you to die or take someone's organ before they've died. It really has to be after that person has died. Now, from the Church's perspective, death occurs at the moment the soul separates from the body. We don't have any way to see that directly because our soul is a spiritual being, a spiritual part of our being. So there's no direct measure, it's indirect. And so at this time, the criteria is total brain failure, so total cessation of brain function. That's a bit controversial right now, even among good, solid Catholic ethicists, but that is the standard now. If there are, one of the things about the moral life is that you can't demand of a science any more precision than it allows. Mathematics has incredible precision. The moral life has precision, but it doesn't always have that kind of exactitude. And so what the Church asks us to do is have moral certainty, not absolute certainty, but moral certainty. And so that's why it's important to do things like, if there is a question, contact the diocesan bioethicist, contact the National Catholic Bioethics Center, learn about Catholic teaching. But yeah, organ donation, as long as there's a determination that you truly have died, it's completely legitimate and actually seen by the Church as an act of charity. Yes?
So is there a way to specify in the wishes that you want to be brain dead or dead as the Catholic Church will tell you, so that if you say yes, I want to be an organ donor, is there a way to specify the type of death that you want, criteria that you want to meet for that to donate organs?
I think that probably would be a legitimate. I don't see it in our form, but it seems like that's something that you could add. And again, works just like a will. It's just like a will, you're expressing what your will is. And so if you wanted to write that in, that is the criteria that you would want to be used to determine that death has actually occurred, I think that is perfectly legitimate and it would be legal.
I think Priest for Life has a document online that's like that, and I think the two they specifically exclude are heart and eyes. Right. Because there's some, I don't know the medical side of it, but I think they do have some language for that.
Okay, I'm not familiar with that, so I'm not sure. Priest for Life is, I don't know what the status is right now. That's a little questionable right now with Father, or formerly Father Frank Pavones. I don't know, I wouldn't want to get up here and say yay or nay on that, I just don't know enough. But I will say, if there are questions about that, the National Catholic Bioethics Center is great on this kind of stuff, so. Thank you.
Thanks, Steve. All right, we're coming to the end. It's like a marathon. I would say one other thing in regards to organ donation, it is important that you know, if you do organ donation, the funeral will take quite a bit longer. Because they're gonna take the body, they're gonna, harvest the organs, and then they're gonna return the body back to the family. And so there's a little bit more of a process that's involved in that, just so you kind of have a heads up in regards to that. Finally, I'm just gonna ask Chris Redmond to come up, and do you have a quick question, Ralph?
Yeah, can you give your body to science?
Same thing.
Same thing, yeah. You can. Now that one, I've done quite a few, well, not quite a few, I've done a handful of funerals where that happens. And now we're talking months before you would get any type of body back. And that's kind of a weird conversation to have for any type of funeral. So that, I'm not opposed to that, but I do see that the grieving process gets really messed up if you do donate your body to science. And so that's totally up to you, your wishes. But morally it's okay. Yep. Okay. Chris Redmond will have you come up and just talk the last little part about the parish and the documents.
Hi, I'm Chris Redmond. You probably know who I am. If you don't, I'm the Director of Sacraments and Outreach. I'm going to put on my theology and church law funeral guy hat. Addressing the elephant in the room here, we lure you in here with donuts, and then we lay this on you. Are we trying to scare you? Is the church after your money? Are we after your body? No, we care. We care so much about you. And Father is entrusted with the care of your soul. That's a big deal. So, think of it this way. You head out of state, you make sure someone's watching your house, taking care of your dog, bringing in your mail, taking care of the things you care about. Well, when you leave this earth, why wouldn't you do the very same? This is peace of mind. You're doing yourself a service as well as everyone else. And I think today's gospel was perfect about generosity. Where is our opportunity to give? And so we can be generous in a financial sense, but also with our sense of faith. And so putting your thoughts and your testimony of faith on paper, that's a witness in itself to your family and so many other people. And it's incredible. And another little piece to the 20-somethings, 30-something-year-old people in here. I'm not quite 30. Surprise, right? It's the glasses. No, but is this for you? Does this matter? Is this just for, the older generations here? No, this is for everyone. I have the joy and also very heavy, sometimes it's a heavy cross to work with so many families who have lost a loved one, and we're trying to figure out what to do next. And one that really hit me was the death of a lovely young woman who was not much older than me, had young children, similar age of mine, and her husband just needed to focus on grieving, just needed to focus on, what do we tell the kids? How do we move forward with this? And there was no will, there was no plan, there was no nothing. And so now he has to make all those decisions. And I mean, I trust my wife with my life, obviously, she's my everything. But I want to give her peace of mind. I want to allow her to take care of our kids, to go step by step. What do we do next? Well, if I put my thoughts on paper, she knows how to honor me and how to honor our family and to keep it going, right? So it's not selfish to put all of this down on paper. It's not selfish to say, I want these readings, I want this music, this is where I want my body to go. It's a blessing. And you bless not only yourself, but your family, your spouse, because they know how to honor you and how to share their love for you. A couple myths that always gets brought up about cremation. Cremation is not wrong. The church is not against it. In 1963, the church did allow cremation. And if we think about when the church comes down and says no on something, it's not because the church is trying to wreck our lives. It's because the church cares about us. And it's usually in response to some sort of misunderstanding, some sort of abuse. And so we can think about in pagan practices when, the body is thought of as something evil, like a prison, and we want to do away with it. So, the cremation was taking place in a much different sense. Well, now we know, right, that our body is a dwelling of the Holy Spirit. We're body-soul composites. We're going to get our bodies back on the last day. And so the church has said, we can do that, but with a few caveats, right? As long as those cremains maintain the same sense of dignity as a body would. And so sometimes it's hard with that disconnect that we don't see the person anymore. We might see an urn, right? But it's our job at the parish to help you understand too that that's the same person, right? Just in a different form. And so that's why we really harp on that sense of dignity. But the order of the church's preference is in your funeral packet. First of all, body throughout the whole thing, right? From vigil to funeral to burial. Next preference would be, allowing that sense of grief to have a personal connection through the funeral, full body, and then cremation and burial, and then maybe choice 3 would be cremation through all of it. But in no way is the church saying this is a bad thing, because everyone has a different circumstance, whether that's financial, whether that's cultural. But our big thing is that we want to care about the dignity of the person, and we want to celebrate that life as if it was the body still present, because that person is going to be reunited with their soul on the very last day. And so there was a very good question about separating parts of ourselves, like with organ donation. We can think of this in a different way when we separate parts of ourselves for cremation, right? If we give a part of our organs to someone in need, that's an act of charity, right? We're helping our neighbor. If we separate pieces of our ashes, and perhaps, someone has a piece here, someone has a piece there, maybe we make it into a sense of a piece of jewelry. For some people, that's consoling, right? And we want to maintain respect in that view. But then that also brings into consideration the sense of dignity that person has. This is a person. You're not a knick-knack, right? I'll come out and say it. That's not the right place for a person, right? And so we want to be able to put that person in a place of honor, a place of respect that we can return to and remember them, whether that's a columbarium, mausoleum, full burial. We want to treat that person as if it was the full body, the person that you saw right before they passed. And the importance of doing this now. It's an incredible gift to your family. It's an incredible gift to yourself, peace of mind. But make sure you share it with people. Don't let it be a surprise, right? People want to know what you want. And so it might be a weird conversation at first, but let people know there's a plan. Maybe walk them through it. You are welcome to share it with the parish. We keep it confidential. Share it with the funeral home. Share it with your attorney. And we'll help you. Make sure you sign it too, right? Because the grieving process is there's so many levels to it. And people come in with so many emotions. I mean, when I come into a meeting, I'm not coming in swinging on your behalf, but sometimes I really am put into a box, and our funeral homes, we have such a great relationship with them, and they understand where we're coming from, where, sometimes we have to put our foot down to not only respect what the church is saying, but what this person was saying. And so make sure your wishes are very well known. But even before we get to that moment, make sure that you call a priest when you are nearing the end. Make sure you know that someone else knows that that's your wish. Because it's a heartache when we get a call that we know that, someone would have wanted a priest, and we get a call for an anointing, and Father gets there and the person has already passed several hours ago. In order to impart those sacraments, they're for the living. It's a way of getting someone ready for a journey, right, to their heavenly reward. And Father makes himself available at all hours of the night for that. And so don't be afraid to give a call. Don't be afraid to tell people to call, because even that is an immense peace of mind for those who will be grieving, that you know that what they felt is important has been taken care of. And you can have a sure and certain hope that they are enjoying that reward with our Lord in heaven, especially with the graces of the church and with all of these things that we've gotten ready now, so that you can focus on grieving. You can focus on praying for them, and you can focus on being ready to see them again. So that's all I have. Do you have any questions on the part of the church or what we do? All right. Happy to answer any other questions later. Thank you so much for being here.
Just a couple of housekeeping details. Some people were asking, if you look on the medical directives, there's a notary public signature necessary. Lori, come out just so everybody can see you. Lori Freeze, our business manager, is a notary public. So on December 7th, when we reconvene with all of our stuff to share and whatever, she'll be here if you need somebody to sign that document. And then Chris kind of stole my thunder, but I want to double down on that too. The anointing of the sick it's a huge sacrament, and I don't presume that your children know that you want it. They may, but in the minute of when you're passing, that may slip their mind. So make sure that tell them numerous times, right? I want this sacrament, and get it prior to me passing. Sacraments are for the living, okay? Like you said, Chris and I have been through enough that way too often it happens that either they passed or they're already at the funeral home or whatever it is. You're not going to burden me if you call me, well, it's 2 weeks, and what if they live longer? Well, I'll come back. You can receive the sacrament more than you can receive it a bunch, and and it does. It brings immense healing to the family when they see that happen. And some of the most powerful moments I've had, especially in the grieving process, is when I'm praying with the family in that moment. It's really beautiful. It's hard, but it's a really beautiful time. And so just to double down on that a little bit, I want to thank all of our guys here helping out. Thank you for showing up. If you know anybody else that would benefit from this, tomorrow we have at 7 p.m. here, we're going to do the same thing, kind of on a repeat, or we will also have, we're recording it, and we're going to put it on the parish website so that people who couldn't be here can watch it as well. I want to thank my parish team that put a ton of work into this to get everything set up. The diocese, Brian is here as a representative of the diocese. Just put your hand up. There he is. Okay. And they helped out immensely. We'll hang out for a little bit. These guys will be here for a little bit if you have any personal questions. Thank you for coming. And don't let this just be do it. Just go and do it. Get it done, and then bring it back, and we're good to go. Thank you guys. I really appreciate it.